Are we getting timely justice? If not, what are the serious consequences? The answer is we are not getting timely justice. We are getting a delayed justice. Why is it so? What and the serious consequence is this? Problem of delayed justice leads to these problems. What is the problem? Generally, people approaching the court for what? Because they are victimized by somebody's act. They want to get remedy or suitable remedy from the court. So already they approach the court with a wound in their heart, and they need to pay fees to the lawyers. So they wound their hands also. Then ultimately, when there is a delayed justice, it wounds their soul. And what happens is, because of the delayed justice, the people will lose faith in the system, and they will take law into their hands, and there will be a lawlessness in the society. There will be a law and order problem, and there will be a complete chaos. So there should be the ability from the lawyers, there should be a nobility from the judges, and the institution should provide serviceability to the people at large. Then we can bring back the glory of the institution. Having understood the third answer to the question also, that there is a delayed justice. Now moving on to the fourth question, that is, what is the problem and what is the solution for this delayed justice? So now, where is the delayed justice? Is it happening in Supreme Court or in high courts that are functioning in various states, or in district courts? That is a question staring at my face. But it's a vast subject. Within a short span of time, I cannot cover everything. Therefore, Supreme Court, being the apex court, being the top court, being a role model court for the entire courts in India, so let us examine the apex court alone in today's topic. So the problem of delayed justice from the Supreme Court that we are going to analyze today. So Supreme Court is the top court in our country, and it exercises various jurisdictions. One, original jurisdiction. Under original jurisdiction, we have Article 32. Anybody whose fundamental right is violated, they can approach the Supreme Court under Article 32. Section 25 Civil Procedure Code, that is original, that also gives power to the Supreme Court to entertain original jurisdiction. It's a transfer petition, 25 CPC or 406 cr.p.c. It's a transfer petition where you can approach the Supreme Court directly when you want to get a transfer of any case pending either in district court or high court from one state to another state on any reasons. So that is how the original jurisdictions, and Article 131 is also there. The original suit, when there is a dispute between two states. So these are the articles which gives right to the parties as well as to the Supreme Court to exercise its original jurisdiction. Now coming to the appellate jurisdiction. Appellate jurisdiction, there are a number of high courts. When somebody, an aggrieved party, out of the judgment passed by the high court, if he wants to prefer an appeal, he has to approach the Supreme Court. So appeal may be under Article 133 or Article 134 or under Article 136. Or statutory appeals are also provided. under section 38 of the Advocates Act, you can approach Supreme Court. So that is how the statutory appeals and the appellate jurisdictions lies with the Supreme Court. Thereafter, advisory jurisdiction. President of India can seek advice from the Supreme Court on the question of public importance. So that is advisory jurisdiction vested with the Supreme Court. Then review jurisdiction. When there is an order passed by the Supreme Court at the stage of SLP, then remedy is review against the dismissal of SLP, review jurisdiction. Thereafter, curative petition. After dismissal of review, we can prefer a curative petition. So these are the various jurisdictions vested with the Supreme Court. Now, to understand the problem of delayed justice, we can refer to the annual report issued or published by the Supreme Court of India in the year 2018. According to the report, Supreme Court said there are 56,000 and odd pending cases in the Supreme Court. And if you analyze why there are so many pending cases in Supreme Court, we get the answer is the delay attributable to the docket explosion of special leave petitions. The problem lies with more number of cases being filed before Supreme Court under Article 136. So what is 136? Is 136 is a special leave sought by the Supreme Court. With the leave of the Supreme Court, you can prefer an appeal against the order. Order may be an interim order or a final order, maybe from the tribunal or a district court or from the High Court. Such a wide power vested with the Supreme Court. But one notable word is most important in Article 136 is discretionary power. Underline or highlight the word discretionary power. If the Supreme Court feels in its discretionary that there is grave injustice happened to the aggrieved party, or when there is a substantial question of law involved, or there is a question of law which concerns the public at large, they can, by exercising their discretionary power, they can entertain special leave petitions. So special leave petitions cannot be treated as a matter of appeal. How do we file under section 96 CPC first appeal or section 100 second appeal before the High Court? It cannot be treated as another appeal. It is not a statutory appeal, a right vested with the litigant, but it is a discretionary power vested with the Supreme Court. That is most important. But the more number of cases are being filed under 136. Maybe frivolous cases also filed. The classic example I can give you. This is my personal experience. When I sat in the Supreme Court for my matter to be heard, there are a few other matters were also listed earlier. One of the matter went and came up before the court, Supreme Court. An advocate stood up to address his arguments before the court. Before he could open, judges asked, "We are going to impose a heavy cost on this petition. You tell us how much cost." I was sitting there and I did not know what is the facts of the case. And I felt in my mind, why judges are so harsh? Here is an advocate, has to represent, it is his professional duty to represent a client, but judges are saying that we will impose cost even before before he could open his mouth. So I was wondering. Later on, I found the conversation between the court and the advocate. Advocate has preferred SLP against the dismissal of a application by the High Court. That application dealt with application for listing of his matter at the earliest, yearly listing of matters. So application was moved before the Honorable High Court. Honorable High Court dismissed. Against that dismissal of the order which rejected yearly listing, that came up before the Supreme Court. But the concept of 136 is substantial question of law. Where is the substantial question of law involved in the dismissal of yearly listing application? Where is the question of public importance? Where is the question of grave injustice? Therefore, the Honorable Court rightly pointed out to the advocate that we will impose heavy cost. Therefore, he did not argue his case. On the contrary, he withdrew it, but there was not cost imposed on him. In the same manner, we can understand the importance of 136, how the frivolous cases are being filed and piled up. So we have understood the main reason for the delay is number of SLPs. 80% of SLPs are filed, and more number of cases are also dismissed. And how do we address, how do we give solution to these problems? How can we reduce the backlog of cases? How can we reduce the pendency? How can we take away the burden of the apex court?